Welcome all, my dear friends. Let's continue our journey in the world of IPR by picking a rule of the Patents Rules 2003. Again the old slide, because in the slide we have established a relation between the sections, rule and form 1. Fine, the sections discussed were section 7, section 54 and section 135, and all these sections we have individually discussed as well. So now is the turn for rule 20. Rule 20 is international applications designating and electing India. Okay, so let's proceed. Okay, Rule 20 comes from chapter 3, which is about international applications under PCT or Patent Cooperation Treaty. The title of Rule 20 is International Applications Designating and Electing India. Okay. Okay. The sub-rules we can discuss here, or we can say the keywords of the sub-rules of Rule 20 are is mentioned in the table. Keyword for sub-rule 1 is international application. Keyword for sub-rule 2 is expiration of the time. Keywords for sub-rule 3 are prescribed national fee, that is for 3A, and translation, that is for 3B. Similarly, for sub-rule 4, for bit 1, or we can say part 1, time limit is the keyword, and for bit 2 or the part 2, examine the application is the keyword. Similarly, keyword for subrule 5 is International Preliminary Examination Report, and keyword for subrule 6 is amended claims. Similarly, keyword for subrule 7 is second schedule. So friends, these keywords are totally based upon my way of looking at the subrules. So you can also find a better way if you can. Fine. Subrule 1 in detail. Okay. An application corresponding to an international application filed under PCT or Patent Cooperation Treaty may be made in Form 1 under subsection 1A of section 7. Fine. The explanation is, for the purpose of this rule, an application corresponding to an international application means an international application is filed under PCT or Patent Cooperation Treaty, which includes any amendments made by the applicant under Article 19 and communicated to designated office under Article 20, or any amendment made under subclause B of clause 2 of Article 34 of the treaty, provided that the applicant, while filing such application corresponding to an international application designating India, may delete a claim in accordance with the provisions contained in Rule 14. So, sub-rule discusses about the international application or the international PCT application that is to be made in Form 1 as per Section 7, and Section 7 is, the title of Section 7 is Form of Application. Fine. And what is the explanation? For the purpose of this rule, means Rule 20, an application corresponding to an international application means an international application filed under PCT. That means we can say PCT international application. It includes any amendments made by the applicant under Article 19 of PCT and communicated to designated office under Article 20 of PCT, or any amendment made under subclause B of clause 2 of Article 34 of PCT of the treaty. Of the treaty means PCT, Patent Cooperation Treaty. And what is the condition? The condition is that, provided that the applicant, while filing such application corresponding to an international application designating India, This one is an important thing. Designating India may delete a claim. That means a claim may be deleted as per or in accordance with the provisions contained in Rule 14. Why Rule 14? Because Rule 14 deals with amendments to specifications. So, what is Article 19 of PCT? Amendment of the claims before the International Bureau. Article 20 of PCT is communication to designated officers. Article 34 of PCT is procedure before the International Preliminary Examining Authority. Fine. So, this way, I think sub-rule 1 is more clear now. And we should remember one thing. Rule 20 sub-rule 1 is amended by Amendment Rules 2016. And for this, please refer the Barrett. Right? The next one is sub-rule 2. The Patent Office shall not commence processing of an application filed corresponding to international application designating India before the expiration of the time limit prescribed under sub-rule 4, clause 1. Fine. So, we can say here the Patent Office shall not commence. That means the Patent Office shall not start processing an application that is filed under international application designating India before the expiration of the time limit. And this time limit is prescribed under sub-rule 4, clause 1. That we will discuss later actually. Okay, so Rule 20 sub-rule 2 is amended by Amendment Rules 2005. So please refer the Barrett. Now is sub-rule 3. An applicant in respect of an international application designating India shall, before the time limit prescribed in sub-rule 4, clause 1, A. Pay the prescribed national fee and other fees to the Patent Office in the manner prescribed under these rules and under the regulations made under the treaty. And B says, and where the international application was either not filed or has not been published in English, file with the Patent Office a translation of the application in English duly verified by the applicant or the person duly authorized by him that the contents thereof are correct and complete. Fine. So we can say 3A emphasizes on the national fee that is prescribed and other fees along with it to the Patent Office in the prescribed manner under these rules and under the regulations of the treaty. That means these two things are mandatory. Fine. The prescribed national fee and other fees to the Patent Office are to be paid is under the rules and the regulations under the PCT. Both are mandatory. And B says where the international application was either not filed or has not been published in English. That means other than English any language is there, then what we can do if we can a translation of the application in English should be done. Just a minute, we can just read it again. And where the international application was either not filed, just take a look here, either not filed or has not been has sorry has not been published in English. That means either in the filing stage or in the publishing stage, it is the language is not English. Okay, then a translation of the application can be filed and it should be duly verified by the applicant who has applied or the person authorized by him. That means the applicant, if authorized a person to do the uh, application procedure, then he is also eligible. So they can, that means the applicant or the authorized person can verify the correctness or completeness of the application, of the translation actually. Fine. Okay, so Rule 20 Sub-Rule 3 is amended by Amendment Rules 2005 and please refer the Barrett for the same. Sub-Rule 4 says, Bit 1 or Clause 1, the time limit referred to in Sub-Rule 2 shall be 31 months from the priority date as referred to in Article 2. Okay, in Article 2, subpart we can say 11, bit 11. Okay, so what is Article 2 about? Article 2 of PCT is about definitions. So here clause 1 says the time limit referred to in sub-rule 2 that we have discussed earlier shall be 31 months from the priority date as referred to in Article 2 clause 11. Fine. Part 2 of sub-rule 4 or clause 2 says, notwithstanding anything contained in clause 1, the patent office may, on the express request filed in form 18, along with the fee specified in first schedule, process or examine the application at any time before 31 months. That means we can say without opposing anything in clause 1, the patent office may, on the express request filed in form 18, if a request is filed in form 18 along with the specified or prescribed fees as per the first schedule, the patent office can process or examine the application at any time before 31 months. So what is form 18? Form 18 is actually request or express, we can say request or express request for examination of application for patent. Okay, so you can do one thing. Form 18, you can just refer the Barrett for form 18. Okay, I am just writing here so that form 18. Please refer it from the Barrett. Okay, now we'll proceed to sub-rule 5. Sub-rule 5. The translation of the international application referred to in sub-rule 3 shall include a translation in English of Clause 1, the description. Clause 2, the claims as filed. Clause 3, any text matter of the drawings. Clause 4, the abstract. And Clause 5, in case the applicant has not elected India and if the claims have been amended under Article 19, then the amended claims together with any statement filed under the said article. Then Clause 6 is, in case the applicant has elected India and any amendments to the description, the claims and text matter of the drawings that are annexed to the international preliminary examination report. So, the letters, the words in bold and the highlighted one are the important ones. So, you can just remember this sub-rule with this clause. I don't think anything is needed to be explained here. So just remember these two things, clause 5 and 6. One is for not elected India and one is for elected India. Fine. So next we'll go to sub-rule 6. Sub-rule 6 says, if the applicant fails to file a translation of the amended claims and annexures referred to in sub-rule 5, even after invitation from the appropriate office to do so, within a time limit as may be fixed by that office having regard to the time left for meeting the requirements, the amended claims and annexures shall be disregarded in the course of further processing the application by the appropriate office. So the keyword here is the amended claims. So this is a condition actually. If the applicant fails to file a translation of the amended claims and annexures means in addition to a document or supplement, we can say, as per rule 5, even after the invitation of the appropriate office. That means an invitation from the appropriate office has been done. Still they fail to file the translation within a particular time limit as fixed by the office, having regard to the time left for meeting the requirements, the amended claims and annexures shall be disregarded in the course for further processing. Fine. So next one is sub rule 7. The applicant in respect of an international application designating India shall, when complying with sub rule 3, preferably use forms set out in the second schedule before the appropriate office as designated office. So what does sub rule 7 says? It says that the applicant in respect of an international application designating India, when complying with sub rule 3, preferably use forms set out in the second schedule. Okay, for second schedule you can refer the direct before the appropriate office as the designated office. Okay, what is the appropriate office? Actually the appropriate office can be the patent head office or any branch office, or I would suggest you that for detail what is an appropriate office can be, what can be an appropriate office, please refer to rule 4 of the patents rules 2003, whose title is appropriate office. It will be more clear. Fine. So the reference is the patents rules 2003. Also I have tried to mention wherever the amendments have been done to the rules. You can refer the Barrett as well for the amendment things, and you can refer to the website of Indian Patent Office as well for more details. Fine. So this way friends, all the sub rules of rule 20 are completed. So please go through my video. Please go through the Barrett. Okay. So well, it is done. So how do you like it? And please share your compliments, comments and any type of queries in the comment box. Okay friends, thank you all. God bless you. Stay safe, stay blessed. Jai Hind.